Do we have a timer up by one of the spectators or opposing team?
Just give us one moment, please.
I'm setting that up right now. Sorry. What is your time allocation?
I believe it's 13 minutes and 50 seconds.
Perfect.
Or Olivia, I can take care of it. You can focus on competing. I'll take care of it.
Thank you.
Yeah, of course.
Sorry, is it 13:50 or 13 and a half minutes?
Oh,
sorry, it's 13:30. That sorry,
yes,
13:30. Yes.
Thank you for that.
Thank you.
Mr. Chief Justice Tutt, and may it please the court. My name is Nathaniel Mowry, and I, along with my co-counsel Maclain Conlin, stand on behalf of Petitioner Mowry in the case at bar. At this time, I respectfully request 3 minutes for rebuttal.
Yes.
Thank you, Your Honor. Petitioner's right to equal protection under the Fifth Amendment, which extends from the 14th Amendment, was violated when Mowry was not accepted into Trinity Medical School while the school tried to fulfill the Native American Medical Care Act, or NAMC, requirements set forth by the federal government. It is for the following reasons that the lower court's ruling should be overruled. First of all, this court should consider the new and evolving precedent of the Fifth Amendment when it comes into conflict with Morton versus Mancari. Second, even though there is a compelling governmental interest in the case at bar, NAMCA does not constitutionally nor logically achieve this interest. And finally, even if this honorable court does not find the preceding arguments persuasive, NAMCA in no way achieves the nearly tailored standard of this court. Moving on to our first argument, that being the consideration of the evolving Equal Protection Clause standards. Now, as this court knows, Morton versus Mancari was based not off of race, but off of essentially political affiliation or national bias, saying that, quote, the preference as applied is granted to Indians, not as a discrete racial group, but rather as members of quasi-sovereign tribal entities, unquote. But as this court has ruled in the case of Yikwo, as cited in Regents of the University of California versus Bakke, quote, the guarantees of equal protection are universal in their application to all persons within the territorial jurisdiction without regard to any differences of race, of color, or of nationality.
Many of those tribes that were considered in Mancari determined their own membership by lineage.
Well, Your Honor, in that given instance in Mancari, they were not considering essentially descendants like they are in this case. One does not even have to be part of a federally recognized tribe, Your Honor. And this leads us on to another point, that this is actually considered heritage and thus a proxy for race. Now, in Mancari, essentially, now specifically talking about Mancari a little bit more, essentially used the future precedent of Regents of the University of California versus Bakke and Wyatt versus Jackson Board of Education, saying that because the Bureau for Indian Affairs was for Native Indians, the ruling in Mancari was justified. But when the issue arose of broader rulings that were not as specific as Mancari, Rice versus Cayetano ruled that the
here it seems to me that having a greater number of Indigenous doctors would contribute to the same goal that was achieved in Mancari, the right to Indian self-governance, right? Isn't it true that Native American reservations oftentimes don't have that many hospitals within them? And so wouldn't it contribute to Indigenous people having access to doctors of their similar background to care for them? Wouldn't that contribute to Indigenous self-governance, just like Mancari did?
Well, Your Honor, first of all, they do still have doctors. If we rule against NAMCA in this given case, it's not like they won't have doctors at all. But so, Your Honor, does that answer your question?
Not really, because what I'm asking about is not necessarily like the access of doctors, but rather the fact that the doctors themselves are Indigenous, right? Wouldn't it further contribute to Indian self-governance if Indigenous tribes or those living on Indigenous reservations had access to doctors that were of their own background?
Well, Your Honor, it possibly would to a certain extent, but that doesn't mean that this isn't a racial preference. In the case at bar, this absolutely is a racial preference, because if we look at Rice versus Cayetano ruled that heritage is a proxy for race. And in the case at bar, NAMCA specifically uses heritage. So in this given instance, this is—
Counsel, can I just ask you, what if the federal government wanted to build a medical school for exactly the class that is identified in this statute, and only for the members of that class as a way of furthering Indian self-government? You would say that is a racial preference that gets strict scrutiny to build a medical school for Native Americans?
Well, Your Honor, I believe if I understand your hypothetical correctly, in that given such situation, that would be a narrowly tailored solution because it's only one medical school. But in this given situation—
But it would get strict scrutiny.
Your Honor, because it would be narrowly tailored, it would be able to pass strict scrutiny if I understand your hypothetical correctly. But even if this court does not find this argument persuasive, we have our second argument, that NAMCA does not meet the first prong of the strict scrutiny test, that being solving a compelling governmental interest. Now, it is not the argument of petitioner that there is no compelling governmental interest. It is the argument of petitioner that this precedent be extended to a compelling governmental interest in which the statute is highly and reasonably likely to achieve the goal of the given interest. And when we look toward the given case, we can see that NAMCA inherently harms Native American communities. The record specifies that petitioner's goal after graduation is to help Native American communities. And this goal has been delayed indefinitely because of NAMCA.
I don't think you can say that it is harmed. I mean, it's— yes, I think the plaintiff here has not been able to be the one that contributes to it, but Congress made a judgment that would be served. How does it serve tribal self-governance to have, even if we were to presume that, there could be some service program where other individuals could come in, how does it serve tribal self-governance to have others coming in from outside the community to act as practitioners? It seems like that's not self-governance, that's just more reliance.
Well, Your Honor, overall, if we look at this, if we allowed other individuals to come in and help the Native American community, we could see that this would actually be fixing the issue. NAMCA is basically a Band-Aid. It's essentially promoting the discrimination among individuals. But if we have other individuals of different nationalities come in, and
don't we have facts in the record suggesting that Native Americans receive higher quality medical care that they're more comfortable with from Native doctors? Isn't that part of the reason we have NAMCA?
Because there have been misunderstandings before with non-Native American doctors, then yes. But if we introduce programs that do not violate the Fifth Amendment and essentially would train doctors to help Native American communities, that's
if non-Native American doctors are the doctors in Native American communities, isn't that the opposite of self-government? Isn't that outside government?
Your Honor, I believe that in that situation, we should be trying to diminish discrimination because this is the Fifth Amendment, Your Honor, which inherently is trying to diminish.
I take your point, but what we're talking about is the governmental interest, right? And it seems like the alternative you're proposing is not serving self-government, even if it serves some other aspects of healthcare interests.
Well, Your Honor, in every situation, we should be trying to limit discrimination, and even at the point of sometimes maybe harming self-governance to a certain extent, because that is the Fifth Amendment. We should obviously be trying to—
But why isn't the most narrowly tailored way to address Native American self-government to train Native American doctors to go serve Native American communities? I'm puzzled by this idea that that's not the most narrowly tailored way to do it. And instead, we should train other people who are not Native Americans.
Your Honor, we aren't saying that we should not train Native Americans. That's absolutely not petitioner's argument. We're just saying that NAMCA itself does not meet strict scrutiny. And if we turn to our third point, we find this to be true. Now, if we look to this court's precedent, we do not have to look at every situation and see if a given situation or a given act is narrowly tailored completely. But as this court has ruled in the case of Bakke, racial quotas are never allowed under narrow tailoring. As we have proven, ancestry or lineage is a proxy for race. In NAMCA, lineage is required. Colleges have to fill 5% of their seats with Native
But
American.
counsel, I guess I just want to ask you why. The quota system is obviously not narrowly tailored to serve an interest in diversity. But why isn't a quota perfectly tailored to serve an interest in self-government?
Your Honor, it could serve as an interest towards self-government, but this is a racial quota as it does rely on heritage. And so therefore it does fall under strict scrutiny, Your Honor.
Would you agree that someone doesn't need to be any particular race to qualify under NAMCA? They could simply be adopted into a Native family and be white or Hispanic or Black?
Your Honor, we would say that that would be the minority of circumstances. This act is specifically trying to aim towards Native Americans, Your Honor.
Well, by
Have we
that same
ever- You can go, Justice Pigeon.
But by that same token, if it's more likely to be an individual of a certain ethnicity, wouldn't you say you're race neutral alternatives? They're not really race neutral. If we have a program that says if you want to live on a reservation after you graduate, if you want to work with Native American patients, individuals who voluntarily sign up for that program are probably statistically more likely to be Native American. And so why is that a race neutral alternative if we have a program where people might be more likely to be ethnically Native American there compared to what we have here?
Well, Your Honor, if I understand your question correctly, in that given situation, we would not be using a quota, which would be completely fine under this court's precedent. But because NAMCA is using a racial quota, then it fails at narrow tailoring. Every single
Okay, well,
time.
let's say we had a quota of people who would commit to serve Native reservations. I mean, that quota will be met by people who are disproportionately Native, but not all Native. The same way this quota will be met by people who are disproportionately Native, but not all. What's the difference here?
Your Honor, the difference is that it's specifically looking at heritage, which is a racial preference, Your Honor. So colleges have to fill 5% of their seats with Native Americans related in some way to other Native Indians or tribes. And thus,
Mr. Mowry, let me give you a hypothetical here. Let's say that Congress was concerned that people from North Dakota don't have a lot of educational options because there's not a lot of colleges in North Dakota, and Congress wanted to expand educational opportunities for those people. And so Congress came up with a plan similar to the one here, except it was open to people who are residents of North Dakota or people whose parents are residents of North Dakota. And everything else in the funding scheme was exactly the same as in NAMCA. Would that be a racially based scheme because it depends on someone's heritage, whether their parent was a resident of North Dakota?
Your Honor, I believe, according to this court's precedent, it could possibly be seen as a racial preference, according to Rice versus.
So
Cayetano.
what would the race be?
Your Honor, I'm not sure if we specifically have named it yet, but under this court's precedent, I believe it could possibly be considered, by definition, possibly a racial bias, Your Honor.
I guess explain to me why that would be the case, because I see North Dakota, just like in this law, I see member of a federally recognized Indian tribe. I don't see anything referencing race itself.
Well, Your Honor, as this court ruled in Rice versus Cayetano, heritage is a proxy for race. In that given situation, they were seeing if Hawaiians from 1778 and onward should be able to vote or not. Excuse me, if other Americans besides those people could vote or not on a given piece of legislation. And this court said that heritage is a proxy for race.
I think what Justice go ahead. I'm sorry, was someone asking a question? No, I think what Justice Tai is getting at, though, is that you're conflating this idea of descendant from race. I mean, in the North Dakota example, you can't identify a single race that applies to North Dakota, whereas in Hawaii, because the descendants were actually going back to a particular racial group, you had that. But in North Dakota and in Native American membership, just because you're going back to someone who used to be a member of a tribe or whose parents were a member or were a resident of North Dakota, that was not ever a racial group, right?
Your Honor, I see that my time is about to expire. May I answer that question and briefly conclude?
Yes.
Thank you. Your Honor, Hawaiians are considered under the same precedent as Native Indians. And in Rice versus Cayetano, this court said that heritage is a proxy for race. This given act is absolutely looking at heritage, and it is a proxy for race. It's for the reasons presented.
And now we will hear from your co-counsel.
Honor, and I may proceed.
Yes, please proceed whenever you're ready.
Thank you, Your Honor. Mr. Chief Justice, and may it please the court. My name is Maclain Conlin, and I represent the state of New Storke, the petitioner on the 10th Amendment issue. Our Constitution is based on the separation of powers, and whenever Congress tries to rob states of their sovereign authority, it violates our founding document. The Native American Medical Care Act forces states to enact a federal policy and does not leave them with the ability to refuse. Congress can entice states to adopt a certain policy, but it cannot, consistent with the 10th Amendment and this court's precedents, coerce them into doing so. We present three arguments. First, Section 4A of NAMC is unconstitutionally vague, in violation of this court's holding in South Dakota versus Dole. Second, under this court's holding in NFIB versus Sebelius, Congress cannot coerce a state to adopt a federal program. And third, NAMC does precisely that. Beginning with the first issue, Your Honors. In South Dakota versus Dole, this court said that, quote, if Congress desires to condition the state's receipt of federal funds, it must do so unambiguously, enabling states to exercise their choice knowingly, cognizant of the consequences of their participation, end quote. However, in Section 4A of NAMC, the act says that any medical school which does not keep its tuition at, quote, reasonable levels will be kicked out of the program. But NAMC never defines what a reasonable tuition rate actually is and provides no guidelines for making that decision. Thus,
so why not bring that lawsuit? Why not bring that lawsuit after someone joins the program and it's too vague? You're trying to strike it down across the board.
What we're trying to say, Your Honor, is this particular. So we challenge several parts of NAMC under Section 4. We're specifically challenging this portion as well, because under NFIB versus Sebelius, and whenever Congress tries to condition the state's receipt of federal funds, it must, quote, function like a valid contract. And that comes with two prongs. First, the contract must be
what it says is not just reasonable. It says that the secretary shall issue such regulations as are necessary to determine reasonableness. So I assume that's happened, right?
Respectfully, no, Your Honor. We have two responses to that. First of all, this court has never held that the decisions of an executive agency can supply clarity in a statute where the statute is itself vague. And second of all, Your Honor, according to the facts of the record, the Secretary of Education has issued no such regulations in the case at bar. So at
Does
a
it say
bare
that
minimum,
they
would
have
ask
not
this
issued a
court to-
regulation, or is it simply silent as to the existence of a regulation?
The record provides a detailed statutory and administrative history of this act, Your Honor, and it provides no mention of such regulations. And as a
Why
result,
would
this
it?
court
It
must
is-
assume that
the
the
reasonableness
regulations-
has not been raised in any lower court.
Respectfully, no, Your Honor. We challenge this under the anti-commandeering doctrine in the lower courts, and NFIB versus Sebelius. Chief Justice Roberts specifically noted that the anti-commandeering doctrine has two prongs. First, clarity, and second, whether it's voluntary or coercive. And we would argue that it
Just
fails
so
both
I
prongs in the
understand,
case at bar.
and I apologize for interrupting you, counsel, but just so I understand your argument, you're saying that it is so impossible to figure out what is reasonable that you can't possibly join this program in a way where you're not unconstitutionally coerced, that the word reasonable doesn't have essentially any fixed meaning that you could possibly wrap your mind around as a state?
We
Isn't
would
that
say,
what-
Your Honor, that under, oh, I'm sorry, Your Honor. So under Dole, the terms must be, I'm sorry.
No, please. I didn't mean to interrupt you.
I'm sorry, I just wanted to say that under Dole, the terms must be explicit. Many people might have different views as to what a reasonable medical school tuition rate actually is. And very often it depends on the particular circumstances of that school. Congress could have done something else, like saying current tuition levels are reasonable, but linking them to the consumer price index going forward, but it chose not to. And furthermore, Your Honor, even if the statute standing by itself was adequate, the Secretary of Education has issued no such regulations. And as a result, at a bare minimum, we would ask this court to enjoin an enforcement of Section 4A until the Secretary of Education tells us what is legal and illegal under this statute, Your Honor. And turning to the issue of
Mr. Conlin, I don't think the Court of Appeals addressed this reasonableness of tuition question. Is that something you waived? Is that something we remand for, consideration below? What are we supposed to do with that?
Your Honor, the Court of Appeals did not specifically address the vagueness issue in its opinion. However, we would argue that the anti-commandeering doctrine is a multi-part test, and vagueness is one of those prongs. So we are permitted to raise that before the US Supreme Court because this court agreed to hear whether or not it violated the anti-commandeering doctrine. But furthermore, Your Honor, even if the terms of this law were clear, in effect, the law is still coercive, and thus it violates the second prong set forth in Sebelius. The record notes on page 4 that medical schools that did not comply with NAMC experienced a 75% reduction in their applications. And furthermore, a poll was done among students at Trinity Medical School, and they were asked,
why should we care about the reduction of applicants, right? The record doesn't say anything about whether these schools have had struggles in terms of, convincing or filling their class or ensuring that they receive the requisite tuition payments to stay open. In fact, no schools have closed as a result of NAMC. So shouldn't we wait and see what the effects are before striking down the law?
Respectfully, no, Your Honor, and I have two responses to that. First of all, page 4 of the record does say that these medical schools have experienced, quote, enrollment difficulties, end quote. And second of all, Your Honor, in NFIB versus Sebelius, technically, Congress taking away all the state's pre-existing Medicaid funding did not make it impossible for a state to, say, adopt new Medicaid programs provided with state taxes. But this court still held that it was unconstitutional because if a state refused to go along with the Affordable Care Act, it would suffer severe and immediate harm. Exactly what's happening here.
Let's take a hypothetical. Let's say Congress passes a law to address climate change. It says we're going to we are going to subsidize state utility companies if they use green energy instead of, say, drilling oil or coal or what have you. Can the state of Texas bring a lawsuit that says we are being coerced into switching to green energy and we don't want to do that?
It would depend on the particular effects of that law, Your Honor. For example, if that law resulted in the closure of nearly all of the state of Texas's energy companies, then it might be coercive in that case. However,
so Congress
Your Honor,
can't give money for green energy because it might cause negative effects on oil companies?
Well, under NFIB versus Sebelius, Your Honor, a program can be voluntary on paper and still be coercive in practice. Under Sebelius, the standard is whether or not in practice that law puts a gun to the heads of the states. In this case, Your Honor, it certainly does. State medical school officials, government actors are given a simple choice: either comply with the federal dictates of NAMC or risk closure. And the Constitution does not allow the Congress to give states such an ultimate.
Oh, I apologize, Justice Sarp, if you want to ask, please.
Oh, no, go ahead. Mr. Chief Justice, you can.
I was just going to ask another hypothetical, which is, what if Congress conditioned the receipt of any federal funds of any kind for a institution of higher education on not discriminating on the basis of sex? So this would be hundreds and hundreds of millions of dollars in federal grant programs, all student loans, this entire federal student loan program, everything. If you take any of that, you must not discriminate on the basis of sex. Would you say that a university that didn't want to comply with that dictate would be unconstitutionally coerced?
Well, under Sebelius, Your Honor, if that applied to pre-existing grants, I would say probably yes.
Let's say it does apply to pre-existing grants. Let's say it's already the law.
Well, respectfully, Your Honor, we would say that, so you may be referring to Title IX regarding gender equality. We would say that under Title IX, simply losing funding for an athletic institution that does not result in the closure of the school is not unconstitutionally coercive in the same way as a grant, which by definition will probably result in the closure of that school. In this case, Your Honor, there's a choice.
Do we have to agree with you quickly on the factual issue that this is going to result in the closure of schools for you to win?
Not necessarily, Your Honor, but we would say it's a contributing factor. In this case, a 75% reduction in applications, severe enrollment difficulties, which by definition also involve financial difficulties, weighs against the constitutionality of this law, Your Honor. In Prince versus United States, state and local law enforcement were given a choice: either enforce a federal gun control law or face a penalty. And in the same way here, Your Honor, state medical school officials were given a choice: either help enforce a federal law or face a severe penalty.
Mr. Conlin, I do think there's a big difference here between Prince and the current situation, which is that this is a law that applies to both public and private schools. And I think we said in Reno that a generally applicable law that regulates state officials as well as private individuals doesn't raise a constitutional problem. What do we do with that?
We would say this law is very different from both Reno and Garcia versus San Antonio, Your Honor. In both of those cases, it was simply Congress prescribing a general regulation, and then states could choose whether or not they would follow, states were required to follow it. For example, in public accommodations law. However, in this case, Your Honor, it's not the federal government simply passing a general regulation. It's telling states, we're going to offer this funding and we want you to enforce this law as if it were your own policy. And Congress cannot commandeer the enforcement mechanisms of states in order to enforce a federal policy, which they would not have done otherwise.
Can Congress, could Congress just, impose this 5% requirement on all universities without making it a condition?
We would say, Your Honor, in that case, Congress, sorry, Your Honor, Congress probably would not have the authority to do that under Article 1, Section 8. It wouldn't run into quite the same anti-commandeering concerns under Garcia, San Antonio, and under Reno versus Cobden, but we would say that it would probably exceed Congress's enumerated powers. So it would have a
Why would this not be an interstate commerce situation? I mean, we have medical schools that accept applications from people from all over the country. I guess my question is, if I think there's a plausible argument that Congress could just unilaterally impose this requirement. So why can't it impose it as a condition?
We would say, Your Honor, because under Prince versus United States, states possess their own ability to enforce the law as they see fit. And Congress can pass whatever laws it desires, but it cannot force states to then help it enforce that law. States must have the authority, if they disagree with a certain federal policy, to refuse to aid in enforcing it. However, in this case, Your Honor, states simply don't have that ability. It's not as if they can simply turn off NAMC. They are required to either obey the dictates that come with these federal funds or face severe and significant economic hardship.
Let's say that the schools didn't have to shut down who aren't complying with NAMC. They just became significantly less prestigious and still were able to keep their doors open while being less competitive schools. Would your argument still be able to be viable?
It would depend on the specific circumstances, Your Honor, but I would say probably not if they still kept their prestige and a large number of students, because under South Dakota versus Dole, a minor change in funding or even a minor change in students would not be unduly coercive. However, in Sebelius, this court said the standard is whether or not it effectively acts as a gun to the head. In that case, it doesn't sound like it would be a gun to the head like it is here, Your Honor. In this case,
Counselor,
yes, Your Honor.
why can't the schools just take this opportunity to revamp themselves, attract new students, attract new programs, think outside the box and make themselves competitive? I mean, there's nothing guaranteed, and certainly none of these schools have shut down. I'm kind of stuck on that point. I don't see this as a death knell to medical students that don't participate.
Well, we would respectfully disagree with your first argument, Your Honor, because this court explicitly rejected it in NFIB versus Sebelius. In that case, Justice Ginsburg used the argument, well, states can find other ways to fund their Medicaid programs without federal funding. They can raise other state taxes, for example. But this court recognized the severe and immediate harm that would come from taking away pre-existing Medicaid funds, made the law unconstitutional.
Counsel,
the same way
I do see you're close to the end of the time, but why couldn't they just increase their enrollment by 5% and then give those 5% of the seats to Native Americans? Why is that such a harm?
They could not do that, Your Honor, because it violates the Equal Protection Clause to the United States Constitution, and these schools believe it would commit racial discrimination. For my co-counsel's issue, certain states have disagreed with this policy, and Congress cannot coerce them into adopting it without destroying our federalist system of government. We respectfully ask this court to hold the government's actions in this case unconstitutional. Thank you, Your Honor.
Thank you, counsel. Okay, we will now hear from counsel for the respondent. Counsel, you may proceed whenever you are ready.
May it please the court. Good afternoon, Chief Justice and Honorable Justices. My name is Caitlin Urali, and I, along with my co-counsel Olivia Robbins, represent Respondent, Secretary of Education Elise Pritchett. I am addressing the first issue of whether the Native American Medical Care Act, or NAMC, violates the Equal Protection Clause of the Fifth Amendment. We ask that you find a violation did not occur for 3 reasons. First, under NAMC, the classification of Native Americans is political. Second, NAMC survives the rational basis review required of political classifications. And third, if this court were to determine a qualified Indian is a race-based classification rather than political, it still survives the strict scrutiny standard. First, under NAMC, the classifications of Native Americans is political, per the decision in Morton v. Maclain, where the Native American classification in the Indian Reorganization Act of 1934 was political, not racial, as it served for the purposes of furthering Native American
But
self-government.
I think the distinction is super clear here, right? As your opposing counsel mentioned, Maclain had it as its basis in determining who a qualified Indian would be as someone who lived on or near a reservation. That to me seems very clear as a political link. But here, one only has to be somewhat distantly related to a member of a tribe. And here, the key operative word is related. How does that not use ancestry as a proxy, but rather still use a political classification?
Well, Your Honor, it's not necessarily ancestry, it's grandparentage, because in that hypothetical of a Native American family adopting a white child, they're still considered a qualified Indian applicant under NAMC, and they can still be accepted in medical school as part of that 5% set aside, because it's the blood that matters. It's not the culture, which led to the classification of Native Americans under NAMC. In Rice v. Cayetano, the ancestry-based qualification was seen as race-based, but there's a distinction between Rice and the instant case. In Rice, 50% of an individual's ancestry had to go back to Hawaii in 1778, a much more distant generation that could have led to a misunderstanding of the native Hawaiian culture.
So how many generations do we go back in order for something to convert from a political to a racial classification? Is it, if we tie it to, you have to have a great grandparent, a great great grandparent, a great 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 grandparent? Where do you draw that line?
Your Honor, we do concede that if it was a great grandparentage, then it would be a racial classification, because there would be no connection to most people don't live to see their grandparentage.
But lots of people know their great grandparents. Perhaps they would know them more if they had better access to medical care. But it's very common for people to have met their great grandparents, right? And so why would we draw the line simply at grandparentage when there's plenty of people who've never even met their parents, and plenty of other people who are close with great grandparents?
Well, Your Honor, great grandparentage is much more distant, and there are many individuals who see grandparentage as a leading member in their life.
Counsel, I apologize. Please answer.
Would you like to?
Well, now I've interrupted you too much. I apologize. I was just going to ask if this classification, everything's the same, but it is enslaved persons. So your grandparent had to be descended from directly and exclusively from enslaved persons. Would you say that that is not a racial classification because of the adoptions?
No, Your Honor, because there's a second distinction between Rice and the instant case. There's also the distinction of this court has specifically called Native Americans quasi-sovereign entities that are a political classification. Native Hawaiians in Rice and in the hypothetical you gave of African Americans, then it is.
I actually didn't give African Americans. I gave enslaved persons. So, but it sounds like you are saying that it is a racial classification.
No, Your Honor, and
that hypothetical would be, and I don't.
Yes, that's what I'm saying. Sorry if that was unclear. In your hypothetical, that would not be a political classification, but rather a race-based classification, because this court and Congress have specifically considered Native Americans to be
because they were Native American persons who were enslaved people.
Then they would. If it was Native Americans in the past and it wasn't African Americans in the past, then it was only unless this court and Congress has considered Native Americans as quasi-sovereign entities that it would be political.
Understood, counsel.
Second, NAMC's political classification of Native Americans has led to its subject to rational basis review. There are two prongs to rational basis review. One, the government has legitimate interest in NAMC. Our friends, the petitioner, can see that there is government interest, but we would like to highlight the government interest has is improving the general welfare of its citizens, specifically Native Americans who have long been subjects to second-class citizens in this country. On page 2 of the record, the United States Indian Health Service found that for every 10,000 people, tribal reservations have an average of 5 physicians.
Counsel, I understand this argument that you're making here, but wouldn't it be contrary to the general welfare of improving the health outcomes of Indigenous communities by denying someone like Alex Murray, who has shown an interest in improving health outcomes of these communities, in particular, an opportunity to become a doctor and practice medicine?
Well, Your Honor, Petitioner Alex Murray is simply an exception to a commonly shown pattern. If it were true that non-native medical graduates work on reservation upon receipt of their medical license, there wouldn't be such a devastating medical crisis. Congress has the duty to serve the general welfare of its citizens, and NAMCA is an act essential to pursue this duty.
Before you go
please.
any further into your hang in your hat, if you will, that this, definitely is political, what Congress is doing and not racial.
Yes, Your
What
Honor.
if we disagree and we're going to end up applying strict scrutiny? Don't you just end up losing?
No, Your Honor, as NAMCA also survives the strict scrutiny standard required of race-based classifications. Strict scrutiny has 2 prongs. One, there's compelling government interest behind NAMCA. We've already established that there's compelling government interest through our friends, the petitioner's concession. But we would also like to highlight that Native Americans live an average of 5.5 years fewer than the general United States population. When the current lack of doctors on tribal reservations has led to the early deaths of Native Americans that have already faced ill treatment in this country, there's a clear government interest in providing Native Americans.
So, counsel, I apologize for interrupting you. But I hear you saying that the interest is really in higher quality medical care. So I really want to push you on this. If the statistics showed that African American doctors on reservations would significantly improve health outcomes, would the 5% set aside program still be constitutional for the exact same reasons? Because of course that would get strict scrutiny and it would just need to be narrowly tailored. So
Yes, Your Honor. Sorry.
no, please. So I just want to confirm that you think that set aside would be also constitutional.
Yes, Your Honor. It would no longer be a political classification, but instead it would be race-based, but NAMCA still survives the strict scrutiny standard. So if it had the same qualities of NAMCA, then it would also survive the strict scrutiny standard as well in your hypothetical.
Why do you not lose under Gratz and under Bakke in that situation? I mean, it's a clear quota that you conceded would be race-based if it was, for African Americans. And I think we said, in the past that you can't just set numerical thresholds. That's just preferencing race for the sake of race.
Well, Your Honor, no, as in there's a different government interest. There's a different interest in Bakke and Grutter than the instant case. In the instant case, the government interest is to provide the general welfare of its citizens, specifically Native Americans who have a clear medical health care crisis. In Bakke and Grutter, it was for the purposes of the educational benefits of a more diverse student body, which is simply not the case here. The second strongest.
Oh, I apologize, counsel. So if it were African Americans, but now it's African American communities. So we need doctors in African American communities because of health outcomes. Would you say it passes strict scrutiny?
Well, Your Honor, African American communities are more aren't a set aside group as other than like tribal reservations. It is a set aside entity that have different culture. And while there is a different culture in
but
Americans, it's not.
The need for medicine knows no nationality, right? I mean, everyone needs doctors.
Of course not, Your Honor, but there would be different ways to go about it, as in putting more doctors in Native American areas. But in African American areas, they're not seen as separate political entities. Native African American neighborhoods technically don't exist. Other than
counsel, I guess, going to that point, I see there's a bigger problem under strict scrutiny, which is that nothing in the record before us shows that the government even considered race-neutral alternatives, much less that it concluded that those alternatives were not workable or feasible. Doesn't that just doom you under strict scrutiny?
No, Your Honor, as in the case Fisher versus the University of Texas at Austin, the Congress does not have to exhaust all race neutral alternatives.
No, but counsel, I believe the University of Texas actually did studies and submitted evidence to the court showing why the proposed alternatives would not have been workable in that case. And that's what we relied on in reaching the conclusion that the program was constitutional there. I don't see anything in the record. I mean, maybe I'm missing it. You can point me to where I should be looking, but I don't see anything showing that the federal government here considered alternatives.
No, Your Honor, and while there might have been alternatives that were considered in the University of Texas at Austin case, it just set a precedent that Congress does not have to exhaust all race neutral alternatives in pursuit of the general welfare, which NAMC does.
But does Congress have to explore any race neutral alternatives? Is it okay under the standard to just go straight to race without considering any at all, as it appears may have been the case with NAMC?
Well, Your Honor, we don't know if that was the case, that they didn't consider anything at all. It's just not directly stated in the record. But the grandparentage clause, which we contend is a political classification, it's still, there's a graded likelihood, stating page 9 of the record, that Native American doctors are more likely to practice on a reservation in the long term and are better equipped to navigate the healthcare challenges facing reservation communities. Furthermore, individuals without a familial connection to a tribe are far less likely to practice medicine on a reservation. So it's clear that the grandparentage clause is the way to go about it for NAMC. Petitioner alleges that NAMC is not narrowly tailored since it doesn't put more Native American doctors on reservations. However, simply producing more Native American doctors to spread the culture allows for other Native Americans to seek them out and will improve the Native American medical care crisis. The quality of medical care is also improved when Native American doctors are serving Native American patients. On page 2 of the record, Native American patients are statistically more likely to achieve high quality health.
I mean, under the framework of scrutiny, right? If we're presuming for the moment that this is race based, would you say that is a valid, that would also justify similar racial preferences for placement of African American doctors in African American communities, South Asian doctors in South Asian communities, that kind of thing?
Well, Your Honor, South Asian and African American, they're not specific political entities as described in.
Right. But if we're getting to strict scrutiny, we've assumed that this is a racial group, right?
There's really no set aside such thing as a African American community. It is a group of people, but there's no specific geographic location that is specifically set aside for African Americans.
Right, but this law doesn't require you to live on a reservation either. It has nothing to do with your geographic location. It's about who you're related to.
Well, Your Honor, this court specifically has set aside an obligation to serve the Native American communities, which, while we have harmed Native Americans and South Asians in the past, it is not a specific set aside obligation as this court and Congress has.
Why wouldn't it have been more narrowly tailored to have the exact same statute, but it increases the size of the medical school class by 5% and gives the seats to Native Americans?
Your Honor, can you clarify what your question is exactly?
So it would be the same deal, but you go from 100-person class to 105-person class. The 5 extra people paid for entirely by the federal government are going to be Native Americans. So there's no diminution. All we do is expand the number of trained doctors in the United States. We just make sure there's more who are Native American. So there's not zero sum. Why wouldn't that be more narrowly tailored? Then no one had a seat that they could have had before that they can't have now.
Well, Your Honor, I see my time is about to elapse. Can I answer your question?
Please.
Thank you. Well, that would be having schools have to open more opportunities and expand their classes, the class sizes. It's just not fair to schools to do that. So the set aside also allows non-Native applicants to attend. They still have 95%, but it just expands the opportunity for Native Americans who have been subject to second-class citizenry in this country for centuries. In conclusion.
Thank you, counsel. Sorry. All right. It's okay. Sorry, I didn't mean to interrupt you, but it's okay. We have your argument, and I hope you don't feel.
No, of course not. Thank you,
We
Your
have
Honor.
your argument. Thank you very much. We'll hear from your co-counsel now. Please, whenever you're ready.
May I proceed, Your Honor?
Yes, you may.
Chief Justice Tutt, honorable justices, and may it please the court. My name is Olivia Robbins, and today, along with my co-counsel, Caitlin Urali, together we represent the respondent, Elise Pritchett, the Secretary of Education. Of the two issues, I will be addressing the second issue, that Section 4 of the Native American Medical Care Act, or NAMCA, is constitutional in accordance with the 10th Amendment, and no violation of the anti-commandeering doctrine occurred. Your Honors, there are 3 reasons why NAMCA is constitutional. First, the federal government has the authority to use economic motivation in order to incentivize states into complying with desirable legislation. 2, the federal government has the power to tax and spend to provide for the common defense and general welfare of the United States. And 3, the benefits offered for adopting NAMCA do not constitute coercion and accordingly do not commandeer the authority of the state of New Storke. First, Your Honors, the federal government has the authority to use economic motivation to persuade states into complying with legislation. However, outright coercion is not allowed pursuant to New York v. United States, but it has long been held, according to South Dakota v. Dole, that objectives not thought to be within the enumerated legislative fields may be attained through the use of the spending power and the conditional grant of federal funds. Now, Your Honors, if we look closer at the case of New York v. United States, there were 3 prongs that were evaluated for coercion. The 2 prongs that were found to be not coercive were monetary incentives. And the only prong that was found to be coercive was a take title provision that had nothing to do.
Do you agree that monetary incentives can be coercive, though, in principle?
Yes, of course, Your Honor. We're happy to concede that monetary incentives can be coercive. However, it is our contention in the present case, the monetary incentive offered today is not coercive.
What would be an example of a monetary incentive you would say is coercive?
Your Honor, an example of a monetary incentive that could be coercive is if NAMCA were to explicitly provide that if schools did not comply with the legislation, that they were to go out of business or to explicitly lose prestige. However, in the present case, we have no provisions that have requirements of the effects that will happen to
Wait, just to clarify that answer, you're conceding that if it were an established fact that the schools would lose prestige who didn't comply, that would be coercive?
No, Your Honor, excuse me. Allow me to clarify. My concession today is that if NAMCA were to establish that non-compliant schools were to be sure to go out of business, then that would be coercive. However, in the present case, there is no coercion present. If we look at the case of Garcia versus the San Antonio Metropolitan Transit Authority, on page 554, it states that the fundamental limitation that the constitutional scheme imposes on the power to protect the states as states is one of process rather than one of result.
Well, by that logic, couldn't they have just ordered all the schools to set aside 5%? Why even offer money? Just make them do it.
Yes, Your Honor. The reason for offering the tuition is to incentivize the states into adopting legislation. The federal government has no authority to force states into complying with the legislation. However, in the present case, there is no force and rather a choice that the states are entitled to make as to whether or not they want to comply with the legislation.
So, counsel, I'm sorry, I just want to clarify. So you agree that the only power that this legislation is being enacted under is the spending clause, that it's not an interstate commerce power situation. Is that right?
No, Your Honor, we do not agree. It is.
I'm sorry, but is that you said that Congress doesn't have the power to force states to adopt these conditions unilaterally?
Yes, Your Honor. It is our contention today that under the taxing and spending power, the federal government has no authority to coerce states into complying with legislation.
No, but what I'm asking is whether the federal government has power under the Commerce Clause to impose these conditions. Because it seems to me that if the federal government could simply impose these conditions unilaterally, I don't see why it would be a problem to do so as a condition of funding, but I'm just trying to clarify your position here.
Yes, Your Honor. It is our contention today that the state is acting, or excuse me, the federal government is acting under the taxing and spending power with the conditions of the federal funding. And so it is our contention today that these conditions on federal funding are related to the taxing and spending power under the federal government's authority to do so. And this directly comes from Article 1 of the United States Constitution, which allows Congress to enact legislation in order to address the general welfare of the United States. And this issue arises today because of the health care crisis from disparities between Native American populations and the general population of the United States. Pursuant to page 2 of the record, Native Americans are at greater risk to diseases. They live 5.5 years fewer than the general population, and there are 5 physicians per 10,000 Native Americans.
So can I interrupt you? I mean, I don't think anyone disputes the legitimacy or the worthiness of the goals of this legislation. Even your opposing counsel doesn't. But I feel like this has been narrowed to just whether this is coercive. It sounds like you agree that if this is coercive, it is unconstitutional. Do you agree with that?
Your Honor, we do agree that if this is coercive, it is unconstitutional. However, in the present case, it is not coercive because schools have other options to increase their attractiveness. They may not go out of business because they have these other routes that they have the ability to take as businesses.
How do you respond to what the petitioner tells us, which is that same argument was raised in NFIB versus Sebelius and it was shot down?
Yes, Your Honor. The case of NFIB v. Sebelius is distinct from the present case due to the issue of dependency. In the case of Sebelius, the states were previously relying on the funds that were taken away. This brings me to another distinction that in Sebelius, it was a taking away of money as opposed to a giving of money present in NAMC. So
if we fast forward 20, 30 years in the future where NAMC's been around the whole time, every single state has adopted it, they've been getting their tuition covered for free because they've all reserved this quota. And now let's say the federal government says, we're going to pass a new policy. You have to increase your quota to 10% or we'll take away those funds. You would say that now that becomes coercive, that becomes unconstitutional to say, we'll take away the NAMC that you were already receiving because they had become dependent on it.
Yes, Your Honor. We're happy to concede that if these states came to rely on the NAMC funding and then it was to be taken away if the states didn't comply with specific provisions, then yes, that definitely would be coercive. However, in the present case, we only have an offering of tuition. And this is not coercive further because even though there are unintended consequences, the Department of Education survey results are only from 4 private schools, which is not representative of neither the entire United States.
Let's take a slightly different hypothetical. Let's say it's been the longstanding practice for 30 years that the federal government subsidizes medical school tuition 100%. And then Congress passes a law that says, okay, to keep getting this 100% tuition subsidy, you need to give 5% of your spots to Native Americans. Is that constitutional?
No, Your Honor, that would not be constitutional per the decision in Sebelius. In Sebelius, a taking away of tuition that the states were previously dependent on is unconstitutionally coercive due to the issue of dependency. But in the present case, we only have a giving of money as opposed to a taking away of money. And so,
but a taking away might occur because this isn't a one-time grant. This is every single year they're paying for the students' tuition. So it's possible under, no hypothetical, under the way that NAMC exists right now for a state to participate in it for 5-10 years, and then stop participating. Now those funds are being taken away. and that now becomes coercive.
Yes, Your Honor. Our contention comes back to the fact that the offer of tuition is a choice that states can make, and it also comes back to the issue of dependency. So in your situation that you presented, it would depend on whether or not the states were previously reliant on the funds. If they were not reliant on the funds, then there would be no coercion present. However, if they were reliant on the funds, then there could be unconstitutional coercion.
I want to test this. This is one vision of coercion that you're putting forward, but I'm not sure it's the vision of coercion in our cases. So I often think of coercion as the thing that they want from you is of disproportionately less value than the thing they would give you if you gave it away. So for instance, in our takings cases, if you want to redevelop your property, the government cannot sort of condition that on you giving up a huge amount of your property rights, because that's an unconstitutional condition, because everyone would accept it because the value of redeveloping your property is so great. So here, what I want to understand is what university in their right mind, unless they have a deeply held moral objection, which it sounds like is what is causing the holdout universities here, is going to say no to this money. And isn't that the definition of coercive? It's so much money relative to what you are asking these universities to do that no sane university, unless they had an extremely deep moral objection, would turn it down. So isn't that the equivalent of just mandating it? And isn't that highly coercive?
No, Your Honor. It is our contention today that is exactly as you stated, the states do still have a decision as to whether or not they want to accept the funds. So even if the offer of funding is desirable to the states, that's the entire point of the allowance of the federal government to issue conditions on the grant of federal funds. They can make the offer of funding desirable because that's what incentivizes states to comply with the legislation. But there is no requirement to comply with this legislation. And therefore, states do still have proper choice and not coerciveness because they're still able to decline the offer of money if they choose.
Counsel, I want to get your response to a claim made by your opposing counsel who argued that this law is unconstitutional just because of the lack of clarity for the conditions, saying that schools may not raise tuition to an unreasonable level is vague, and that in itself makes the law unconstitutional. What's your response to that claim?
Of course, Your Honor. To respond to Mr. Conlin's Dole challenge, as Justice Surani brings up, the discussion of reasonableness is set to be established by the Secretary of Education, which is perfectly clear to the states. It states specifically that the Secretary is authorized to issue regulations as necessary to govern the reasonableness of tuition fees subsidized by this act, pursuant to page 24. This very clearly provides that the Secretary of Education is the one who will make the decisions regarding the reasonableness of tuition fees. This is completely unambiguous, as it clearly states that the Secretary of Education is the one who will make those determinations as to the reasonableness of the tuition.
So, Counselor, do courts have a role if the Secretary of Education gets it wrong?
No, Your Honor. The courts would not have a role if the Secretary of Education were to get it wrong, as the prongs of NAMC specifically state forth that the Secretary is authorized to issue these regulations. So the Secretary of Education does have the authority to issue those regulations as they deem necessary. Further, reasonableness has a subjective and an objective standard, so it's not exactly fair to say the Secretary of Education would get it wrong, because it's very clear that the Secretary of Education is given that subjective point of view that they are the one that is authorized to make those decisions.
Counsel, I want to switch gears while we have a minute left, and I just want to ask you about these time grant conditions. I don't know that we've talked about them yet, but it seems like this technology funding is a little bit far afield from, incentivizing, more Native American doctors. Why is that condition, however small it is, one that is constitutional to impose?
Your Honor, it is our contention today that the time grant is related to the interest of addressing the healthcare issue and disparities between the Native American population and the general population due to the fact the time grant is related to the ability of medical schools to teach their students and therefore produce more Native American doctors for the healthcare issue. However, we're happy to contend that the time grant may be severed if this court disagrees. We see in New York, the United States, and in Sibelius that unconstitutional provisions may be severed, and we're happy to concede that that can happen in today's case. So for the aforementioned reasons, we ask that this court affirm the findings of the lower court and find that NAMCA is constitutional in accordance with both the Fifth Amendment and the 10th Amendment.
Thank you, counsel. Now, I believe the petitioner has reserved some time for rebuttal. Counsel, whenever you're ready, you may proceed.
Thank you, Your Honor. May it please the court. Because NAMCA forces states to commit racial discrimination, it violates both the Equal Protection Clause and the 10th Amendment. Beginning with the Equal Protection Clause, I'd like to start off by addressing Justice Surani's point about geography versus ancestry. Now, in Morton versus Mancari, the law there only applied to members of a political group who were actually living on reservations. However, in Rice versus Cayetano, a law extended these benefits to descendants of that political group, regardless of whether or not they actually had any geographical affiliation with that group. And this court held that ancestry in that case was a proxy for race, and thus it struck down that statute. We would argue this case falls more along the lines of Rice versus Cayetano, because here ancestry is used.
But your opposing counsel differentiated that case by pointing out that in Rice, it was ancestry going back several hundred years. But in this case, it's just your grandparent. So there's more of a cultural familial connection and less of a genetic one. Doesn't that differentiate this case from Rice?
Respectfully, no, Your Honor, because this court never drew a specific line as to when ancestry becomes constitutional or unconstitutional. And it's worth noting that our friends on the other side, when asked if great-grandparentage will make it unconstitutional, they essentially said yes. And there is no arbitrary line in our Constitution which says a benefit given to given to grandchildren, but not given to great-grandchildren, suddenly becomes constitutional and is immune from equal protection scrutiny. This is a racial classification because, as this court said in Loving versus Virginia, as cited by Grutter, quote, this court has consistently repudiated distinctions on the basis of ancestry as being odious to a free people, end quote. And furthermore, regarding the strict scrutiny issue addressed by Justice Reardon, excuse me, I apologize. We would say that in this case, the law is unconstitutional because it fails the second prong of strict scrutiny. It is not narrowly tailored. This court said in Bakke that, quote, to be narrowly tailored, a racially conscious admissions program cannot use a quota system, end quote. That's exactly what this statute does. And as a result, it cannot satisfy narrow tailoring. Now, turning to the 10th Amendment issue, Your Honors, our friends on the other side opposing counsel tried to say that the effect of a law doesn't matter. It's simply the statute as written. However, we would disagree with this. In NFIB versus Sibelius, Chief Justice Roberts specifically said that a law can be voluntary on paper and still be coercive in practice. It's exactly what NAMCA does. Now, opposing counsel also tried to say, well, in 20 years, if this became pre-existing funds, then of course it would be unconstitutional to revoke them. However, Sibelius never drew a specific line between new funds and pre-existing funds. There's a reason for that. Under that view, medical schools could be forced to close down in that 20-year period, and then there would be no need to revoke those funds because state medical schools have already been coerced. That would essentially render the 10th Amendment a nullity by saying we have to wait until this state medical school is actually destroyed before courts can act. In this case, NAMCA does give states an unconstitutional choice, like in New York versus the United States. Either comply with federal dictates or risk destruction. The Constitution does not permit that choice, nor does it permit the federal government to engage in racial discrimination. And we ask this court to strike down both Section 4 and Section 3 of NAMCA.
Thank you, counsel. The case is submitted.